My name is Sid Mendelson. I'm director of the division. On my immediate left is Frank Morrison, head of inspections of the New York Regional Office, and on my immediate right is Mike Berenson, a special counsel in the division's Office of Compliance. I'd like to discuss the ineligible persons Section 9 of the Investment Company Act. Section 9A sets forth the disqualifications of persons associated with an investment company, and it says in effect, 1, that any person in the last 10 years who has been convicted of a crime involving the purchase and sale of securities, or that person's conduct as an underwriter, broker-dealer, or investment advisor, or as an affiliated person of such companies, and as a salesman or employee of any investment company, of any bank or insurance company, shall be disqualified. In fact, it's unlawful for him to serve in a certain stated capacities, either as an officer, director, employee, or investment advisor of a registered investment company. Further, the section goes on and says any person who has been enjoined by reason of misconduct from acting as an underwriter, broker-dealer, or advisor, or as an affiliated person of such people, or as a salesman or an employee of any investment company, bank or insurance company. I want you to show. I want you to notice here in both of these instances that if a person was convicted of just plain stealing from someplace else, apparently it's no disqualification. But if he was enjoined or convicted with respect to an investment, with respect to a broker-dealer, or an underwriter, or an investment advisor, or with respect to a bank, or with respect to an insurance company, he's disqualified. Because here, in all of these areas, there is an element of a fiduciary duty. And as I stated previously in this conference, the duties that most of the people have connected with an investment company are fiduciary duties, those duties of a trustee. Now, a company which any of these persons who were disqualified, in other words, if a person is disqualified and he becomes an affiliated person of a company, he taints the company. In other words, the company, let us assume for a moment that Frank here was convicted of a crime involving an investment company, and Frank then takes a job either as an officer, employee of an investment advisor. So long as Frank is connected with that company, the company is disqualified, the same as Frank is, even if he is an employee. So that the thing to remember is that a disqualified person taints the company, or taints anybody else that he becomes affiliated with. It's almost like a disease.
Excuse me, Sid, if you had an investment advisor and one of its employees was convicted of one of these crimes, could that investment advisor then serve as advisor to a registered investment company?
The answer is yes, after it kicked that guy out.
But as long as that person were still on the staff.
That's exactly right. Now it could file, and some of them have, as you know, file for a relief under both under Section 9 or under Section 6C. But until some relief was given, the investment advisor would be tainted, and that investment advisor, for all practical purposes, would discharge the individual or would hire him. So that this is one of the reasons why we're supposed to do an enforcement check when we have a registration statement to determine whether any people have been disqualified. And on rare occasions, we have found that they were. Section 9B it gives the Commission authority, after notice and opportunity for hearing, to prohibit either conditionally or unconditionally, permanently or for a period of time. It gives them the right to prohibit those persons from acting as an employee, officer, director, member of an advisory board, an investment advisor, the same retinue of jobs, if the Commission finds that that person willfully made any false or misleading statements to the Commission, willfully violated either the 33 Act, the 34 Act, the Investment Company Act, the Advisors Act, or any rule or regulation set forth under any of those acts, or has aided and abetted in those violations. So, the here the Commission has the authority to, in effect, revoke a person's right to enter and stay in the investment company business. I might say that under Section 9A, going back, under Section 9A, when a person is enjoined or when he's convicted, the bar is automatic. That is different than it is under the, as I understand it, under the 34 Act, where it gives the Commission the opportunity, if you will, to bring proceedings and bar a person if the public interest so dictates. In this case, the bar is automatic in 9A. Now, questions have come up in Section 9A, such as, suppose a company is enjoined, and that order of injunction says the company, its officers, directors, assigns, and you know the retinue of terms that it used. If a person happens to be an officer or a director, does that person automatically become tainted, even though his office is enjoined and he occupies that office? Does he thereby become disqualified? Commission has answered that in interpretations and said no, that a person has to be named in an injunction to be disqualified.
So, of course, if you want the automatic bar of Section 9A to apply to a particular individual, you have to name that individual in your injunctive action. And you can't rest on just naming the office that person holds.
9C is comparable to Section 6C, although it has a different qualifications. 9C provides that any person may file for an exemption order to serve in the capacity enumerated above, enumerate officer, director, to get back into the business. And the Commission shall grant the application either conditionally or unconditionally if it is established that the prohibitions of Section A, 1, are unduly burdensome or disproportionately severe, or that the conduct of such person has been such as to make it against the public interest or for the protection of investors not to grant such application. Now, what am I saying here? What I'm saying is this, that if a person is barred by Section 9A, he has two alternatives. Let's assume he was barred by an injunction. He can go to court and attempt to get the injunction lifted. And if the injunction is lifted, the bar disappears. But assuming he won't do that, or he has reason to believe that the court will not lift the injunction, or he has reason to believe that the commission would oppose the lifting of the injunction if the commission was the plaintiff. So he goes before the commission and he indicates that the injunction was for 7 years ago, or my conviction was for 10 years ago, and or 5 years ago, and I've done this, and this, and my conduct is such that you ought to allow me to come back. Or that for what I did, violating Section 5 of the 33 Act 4 years ago, has nothing to do with how I will act as a fiduciary. And therefore, the bar is disproportionately severe. And therefore, lift the bar, either conditionally or unconditionally, and the commission, in the exercise of its discretion, will do so. It may most of these cases, these applications, which are now processed in the Division of Enforcement, are not contested. In other words, people negotiate with the division, and they know when they file the application that the division will notice it, and if nobody asks for a hearing, it will go through. Normally, if the division feels that the person that the bar should continue, it will tell that person so, and the person will probably withdraw the application. There's only been one hearing that I know of, and it had to do with ITT, who was barred, and the result was that its subsidiary could not act as an investment advisor. Its subsidiary insurance company could not act as the investment advisor for the variable annuities. And when it filed an application, as I recall, an intervener came in, and there was quite a delay. I understand now that they have received such an order, or they are in the process of receiving such an order. Any question on Section 9? If not, in the Section 9B, if I could use the word, the disbarment proceeding section was put in the statute in 1970. Prior to that time, it was we used in using administrative proceedings. If the person was registered as an investment advisor, we used investment advisor revocation proceedings, and if the person was a broker-dealer, we used broker-dealer administrative proceedings. But it was very difficult because it was really pounding a square into a round hole. I'd now like to go into section. I think we can go right now into Section 37. Section 37 is a peculiar section in the Act, in that it says that a person is liable for larceny and embezzlement, an unlawful conversion, for a period is liable for prison term for a period of X years. It doesn't talk about violating anything. However, the Section 37 has been litigated civilly between two private clients, and the court held that Section 37 could be violated and could serve a basis for a claim. 2, the Commission has used Section 37 in injunctive suits, and it's used 37 in Section 9B proceedings. So that Section 37, although posed very peculiarly really as a type of criminal penalty statute, can be used as though Section 37 could be violated. And we have used Section 37, as I said, quite often in our both administrative cases as well as our civil cases. Any questions on Section 37? We'll now go into the Commission's authority to inspect or investigate. Who's taking that?
I'll take it. The Commission's authority to conduct examinations of registered investment companies is contained in Section 31B of the Investment Company Act. Section 31B, in effect, says that all accounts, books, and other records required to be maintained and preserved by any person pursuant to subsection A of this section shall be subject at any time and from time to time to such reasonable, periodic, special, and other examinations by the Commission, or any member or representative thereof as the Commission may prescribe. Subsection A. What does subsection A say? That says or requires a registered investment company, and I use the word registered investment company because it doesn't apply to, obviously, to unregistered investment companies. And in this case here, it refers to the investment company's investment advisor as well. Subsection A says, in effect, that it must, or they must, maintain and preserve for such period or periods as the Commission may prescribe by rules and regulations such accounts, books, and other documents as constitute the record forming the basis for financial statements required to be filed pursuant to Section 30 of the Act and of the auditor's certificates relating thereto. The Commission has promulgated rules pursuant to its statutory authority granted in the above sections. These rules, as we have previously discussed, are 31A1, 31A2, and 31A3. With respect to accountants and auditors' records, it must be noted that Section 32C of the Investment Company Act requires accountants and auditors to keep reports, worksheets, and other documents and papers relating to registered investment companies, and to make such records available for inspection by the Commission or any member or representative thereof. You won't find this kind of a provision in any other of the statutes that the Commission administers, except in Section 32C. In situations where the staff is denied access to documents which a company under examination seeks to withhold, you might want to take the position that any books and records which might constitute the record forming the basis for financial statements required to be filed pursuant to Section 30 and which would be available to companies' auditors, as well as the records required to be preserved under the rule. That particular rule is 31A-2A2 of the Act. Those records are required to be made available under Section 31B. we've been fairly successful in exercising our inspectorial rights under that particular provision. If this approach fails, obviously the staff must consider recommending to the Commission that it institute an action to obtain a court order requiring the investment company to permit examination. Perhaps a better alternative is to seek a Commission order of investigation under Section 42 and issue subpoenas for the relevant documents. However, obtaining an investigative order in some cases may be very difficult because the Commission may not want to authorize investigatory proceedings in the absence of at least some evidence tending to show a violation of law has occurred. If you encounter any problems in attempting to assert your inspectorial rights under Section 31B, you should immediately notify your supervisor.
Excuse me, Frank, would the Commission regard as sufficient evidence of violation the mere failure to allow us to conduct the statutorily?
It may well.
Yes, it may well be, and we could go if we were quite certain that this were the case. In other words, that the person had no right to withhold the books and records from our inspection. It seems to me that we might take the route that Frank suggested, or take another route and go in for a mandatory injunction, stating having the court order the investment company, its officers and directors, to make the books available to us. It could they could have an order saying that the investment company couldn't do any business until it made its books available to us. So that there are two ways of doing it, and of course the Division of Enforcement should be consulted, and obviously the inspector isn't going to take any of these proceedings himself. So that his job, as Frank says, is when he is attempting to make a lawful inspection, and his efforts are thwarted. He oughtn't to make a scene. He ought to get, to the extent possible, any written reasons why he's being refused being refused in his efforts, and if possible, he should bring that back to his supervisors. He should certainly try to ascertain the reasons for the refusal, because to the extent that that the person gives you reasons, at least you know what the strategy is that you can use to obtain such records. Anything else?
No.
How about you?
No, that's all.
All right.
How about investigations now? Section 42A of the Investment Company Act permits the Commission to make such investigations as it deems necessary to determine whether any person has violated or is about to violate any provision of the Act, or of any rule, regulation, or order that may be issued under the Act, or to determine whether any action in any court or any proceeding before the Commission shall be instituted. Section 42A also permits any person to file with the Commission a statement in writing, under oath or otherwise, as the Commission shall determine in this case, as to all the facts and circumstances concerning the matter to be investigated. Under Section 42B, for the purpose of any investigation or proceeding under the Act, any member of the Commission or any officer designated by the Commission may administer oaths, affirmations, subpoena witnesses, compel their attendance, take evidence, and require the production of any books, papers, correspondence, memoranda, contracts, agreements, or other records which are relevant or material to the inquiry. Section 42C of the Act permits the filing of in any court of the United States within the jurisdiction of which such investigation or proceeding is carried on of a subpoena enforcement action.
Now, what is a subpoena enforcement action? Well, we issue a subpoena, and for reasons best known to the object of that subpoena, he doesn't comply. We can go into court and get an order of the court to enforce that to enforce the subpoena, and if then the person doesn't comply with the subpoena, he would suffer the consequences of a contempt of court.
Section 42E of the Act permits the Commission to bring an action in the United States District Court to enforce compliance with the Act or any rule, regulation, or order under the Act. Also, upon a showing that such person has engaged or is about to engage in any violative act or practice, a permanent or temporary injunction or decree or restraining order may be granted. And in that context, the statute also says that this order may be granted without bond, which is very important. It should also be noted that in any proceeding under this subsection to enforce compliance with Section 7 of the Act, Section 7 of the Act briefly proscribes certain kinds of transactions that can be affected by unregistered investment companies. The court, and here the court as a court of equity, may, to the extent it deems necessary or appropriate, take exclusive jurisdiction and possession of the investment company or companies involved, including its books, records, and assets thereof, wherever located. And two, and this is an important one too, has the jurisdiction to appoint a trustee who shall have the power to dispose of any or all assets subject to such terms and conditions as the court may prescribe. Maybe you want to...
Well, I've discussed this provision before, and this, as you can see, is a very severe area of Section 42, where the court really is given the power to almost the power of a bankruptcy court to take over the company, and it has the power to disperse its assets. I would assume, and I'm sure, it has the power to liquidate the company, and generally speaking, Section 7 constitutes, in the eyes of the Congress, a very, very serious violation of the Investment Company Act, and probably there is nothing more severe in any of the acts which we administer. Which, in fact, this was the first act that gave the Commission the power to seek a receiver, or as they call it here, a trustee. The Commission has sought successfully receivers under the general equity powers of the court, but here the provision for a trustee is very, very clear, and that trustee has extraterritorial jurisdiction. If you'll notice that the trustee and the court can take jurisdiction of the assets and books and records wherever they are, so that it is not, they don't need an ancillary trustee or an ancillary receiver. As long as the books and records or the assets are in the United States, it seems to me they come within the court's jurisdiction by virtue of this section. It's a very wide section, and we have used it successfully in enforcement actions many times, and with very good results.
Finally, Section 42E of the Act provides that the Commission may transmit such evidence as may be available concerning any violation of the provisions of the Act or any rule, regulation, or order thereunder to the Attorney General, who, in his discretion, may institute appropriate criminal proceedings under the Act.
Now, that under this statute, the Commission does all of its enforcement work except criminal. The Department of Justice handles the criminal work, criminal prosecution under this act, as well as any of the as well as under all of our acts. And I might say that while the Department of Justice handles the case and has jurisdiction over the case, it is the evidence that our staff develops generally that is used as the basis for the criminal prosecution, and our staff stands ready during the grand jury proceedings as well as during the trial to assist the United States Attorney in the prosecution of the case. We sit at the it is not uncommon for us to sit at the counsel table during a criminal case. It's rare, although it's becoming a little more common, where the Department of Justice has us appointed as special prosecutor. Are there any questions on the criminal part? Yes.
I had a question on the civil investigation under 42B. When are those conducted by the Division of Enforcement rather than Investment Management? Are they always done by enforcement?
Yes. Well, this is a matter of the Commission's discretion, as you might understand. At one time, our division conducted all our investigations and all our enforcement efforts, and in 1972, when the Commission was reorganized, all enforcement efforts were consolidated in the Division of Enforcement. Stop order proceedings that Corp Finance used to do and that we used to do, as well as general investigations under all of the acts, are now in the Division of Enforcement. We have a cooperative effort, and the division has an Office of Compliance, which is a liaison office between the field and us with regard to enforcement. And with respect to the Division of Enforcement, we are constantly in a consulting capacity with the Division of Enforcement. We advise the Commission as to whether we think an enforcement action will hurt or help the administration of the acts which we administer, both the Investment Advisors Act and the Investment Company Act. But the Commission has put the chief jurisdiction, if you will, in the Division of Enforcement for all enforcement efforts. But as I said, and I'll amplify, all enforcement memorandum from the field come to the Division of Investment Management. All enforcement memorandum dealing with investment companies or investment advisors come to the Division of Investment Management, and they don't go to the Commission until we have had a chance to comment on them. We occasionally, and very occasionally, oppose the Division of Enforcement. More likely, we go to the table to support them. Generally speaking, it's a very, very close cooperative effort. They look to us as the experts in this very technical area, and we look to them, as Stanley Sporkin says, as our hired gun.
You want me to finish?
Yes.
A question which frequently arises is the point in the examination process where the examination ends and an investigation begins. This is very important for a variety of reasons, including determining the appropriate procedural steps which should be followed, not only in seeking information, but in the generating of statistical information, which is constantly requested by various offices within the Commission itself. Clearly, an examination has become an investigation when a case opening is processed or an order of investigation is issued or even sought. However, the area prior to such action being taken remains somewhat gray. The procedure in the New York office is to consider the matter to have the status of a preliminary investigation at the point where it has been referred to our branches of legal counsel, which I might preface is the enforcement arm of the New York office, or part of the enforcement arm of the New York office. And of course, the branches have indicated in some way that they're interested in participating in the particular matter under review. I should note that that is also our view that the Commission's examination rights under the statute continue to exist even after the matter has progressed into the investigatory stages, whether formal or informal. Although there are no cases exactly on point, there is a great deal of law which supports this position. It is not uncommon in the New York office for us to seek information by subpoena and at the same time seek additional information through the examination process. However, in those instances, we advise the investment company that although we are proceeding pursuant to our examination rights, we are doing so in connection with an order of investigation. Now, there's obvious benefits to that. It eliminates the need for issuing subpoenas for every little piece of paper that you might need to complete your case, particularly those kinds of paper that's readily available under the examination process. Are there any questions?
I want to make one thing clear, that in an investigation, it is not always the staff who wishes to complete the investigation quickly. It is also the company and its investment advisor, because no matter how private we attempt to make the investigation, it's all over the street in 2 days, and the company feels it's under a shadow, it's under a cloud during the course of the investigation. So the cooperation that is given here is in the self-interest of the company in many instances, even though they may well know that they have violated the law, and even though they may well feel that some sanctions are going to be imposed, because they would rather get it over with and have one blast of notoriety than a constant group of rumors running around the street. And so that I have felt, when I was conducting enforcement proceedings, that the cooperation that I was receiving was good, both for me as well as for the persons under investigation. Yes, sir.
Sid Monroe Freeman has recently come out and attacked the Commission for issuing press releases about investigations that are taking place with respect to corporations and those institutions registered with the Commission. I was wondering, with respect to investment companies who might be under investigation, has the division adopted a policy in response to Mr. Freeman's concerns, or...
Well,
repeat the question.
The question was, Monroe Freedman has criticized the Commission with respect to newspaper articles involving investigations, and the person asking the question wanted to know whether we have altered any of our enforcement efforts in view of that criticism. Well, I can only speak to investment advisor, investment company investigations, and as far as I know, the investigations conducted by the Commission, which I am aware of, are done privately, and information is not given to the newspapers and should not be given to the newspapers, particularly by what I call frontline troops. However, just as I said before, it is almost impossible to keep an investigation private. when you subpoena John Jones in to testify, John runs around and tells all his friends, particularly if he's innocent, has nothing to do with the case, but is just a witness. Boy, I was subpoenaed by the SEC today. They're investigating thus and thus and thus, and you can't put a muzzle on that man. And as a result, it gets around the street. It makes excellent cocktail conversation, and it's embellished. Yeah, they said they were going to put those guys in jail. Can you imagine that? Didn't say a damn thing, but it wouldn't be interesting if he repeated what was said. And so that's how it. And the papers get a hold of it. Now, Monroe Friedman makes a hobby of criticizing the commission. So I will just comment on that particular feature. Now, let us continue.
I have a number of sections to speak to you about today, some of which you will deal with regularly, and some of which you'll confront only very infrequently. One of the sections you'll address infrequently is Section 47 of the Act, which has two provisions. The first provision, which is identical to Section 215A of the Advisors Act, makes void any provision or condition which binds a person to waive compliance with any provision of the Act. Further, merely having such a provision in a contract may in and of itself violate various provisions of the federal securities laws, since the person signing the contract, in which he apparently waives rights, waives causes of action, might be misled into thinking that they had waived those rights, whereas in fact Section 47A, of course, does not allow the person to waive those rights. Section 47B of the Act pertains to contracts whose making or performance involves violations of the Act or a rule thereunder. With respect to someone who violates the Act when they either make or perform the contract is void. With respect to a third party who acquires rights under the contract, it is void only if that third party had the information, had actual knowledge of the reason by which the making or the performance of the contract involved a violation of the Act. Now,
I would like to say that while the statute uses void, as a practical matter, in both cases, it's voidable because it's void as to the rights of that person. And it's only when somebody comes up with the defense that the contract is void is it asserted. So it isn't something that never existed. The way I see this thing, the application of this particular provision really makes it voidable rather than void, even though the statute clearly states void.
That's right. I think there are court decisions on that precise point, that this really means voidable, and the court will regularly consider the equities when someone is making a claim that a contract is void. Indeed, the division recently had an application that it considered that raised the question of whether a contract was void. And this involved an application by the American Bakeries Company. And in this application, the factual background was that Mathers Fund, a registered investment company, had in a series of open market transactions acquired a large block of American Bakeries stock. And in fact, it had acquired so much that it was a 5% owner of American Bakeries, and therefore the two companies were affiliates of each other. Subsequently, the fund became disillusioned with this investment and decided it wished to liquidate its position. And at that point, it learned that American Bakeries, the issuer, would be interested in repurchasing those shares. And the two parties negotiated a sale on terms excuse me. I understand that Mr. Mendelson discussed this case in detail earlier, so I will not pursue it any further. But it is just to say that it is a case in which the Commission's opinion, although not directly discussing the Section 47 point, did implicitly reject the fund's contention that this contract was void.
That's the point that I didn't discuss, and that's the point that when the investment company went into court, it went into court under Section 47, charging that the transaction was void because it violated the Section 17 of the 40 Act. At the same time, as I said before, there was an application, and the application asked for retroactive relief, and in comity to the Commission, the court withheld consideration of the case until the Commission had acted. The Commission having acted, the case was moot.
Section 48 of the Act has two provisions. The first makes it unlawful for a person to do indirectly what they couldn't do directly, and the second makes it unlawful for any person without just cause to hinder, delay, or obstruct the making, filing, or keeping of any information, document, or report required to be made, filed, or kept under the Act. Having dealt with some of the less important sections, move on to one of the most vital sections of the Act, Section 36. Section 36 is the basis for the Commission's actions involving breaches of fiduciary duty by persons associated with investment companies. The section authorizes the Commission to bring injunctive actions in United States District Courts for conduct which has occurred during the past 5 years, is occurring, or is about to occur, which would involve a breach of fiduciary duty involving personal misconduct on the part of a person serving in various capacities with investment companies, including as officer, director, investment advisor, or principal underwriter if it's an open-end company. If the Commission's allegations are established, the court can enjoin the respondents from serving investment companies and can award such equitable relief as is appropriate. Now, this right of the court to award equitable relief is very important and is one of the reasons why the Commission will bring injunctive actions under Section 36 in situations where an alternative, if there are substantive violations, might be to bring the case as an administrative proceeding under Section 9b. Because under Section 9b, the only relief that can be awarded is the barring of that person from serving an investment company. One feature about Section 9b proceedings is that a person whose only violation is of Section 36, there's been personal misconduct, breach of fiduciary duty involving personal misconduct, that a Section 36 violation cannot be the sole basis for a proceeding under Section 9b. There must be some substantive violation. The Section 36 conduct can be used in determining the sanction, but it cannot be the sole basis for the proceeding.
The reason for that it seems to be clear. Section 36 is an enabling section. It enables the Commission to bring an action in court. It doesn't. Nobody can violate Section 36. 36 is a breach of fiduciary duty, and the Commission can bring involving personal misconduct. The Commission can bring an action within 5 years from the date. Now, the point that I'd like to make here is that such conduct can be also violative of other parts of the statute, such as Section 17, where where an aggravation, where 17 there is a real overreaching, Section 36, or it can be such that the directors did not discharge their fiduciary duties. The legislative history says in 1970 that although the words personal misconduct is there, personal misconduct can consist of nonfeasance as well as malfeasance. So that where the board of directors had a duty to act and they refused to act, that can be interpreted as a breach of fiduciary duty involving a personal misconduct.
Now, Section 36B of the Act states that the investment advisor to an investment company has a fiduciary duty to that company with respect to the receipt of compensation for services or payments of a material nature to either the advisor or an affiliated person of the advisor. In addition, an action may be brought against any of the category of persons enumerated in Section 36A who had a duty concerning the authorization of such compensation or payments. Section 36B sets forth several very precise principles which govern an action under 36B. First, the plaintiff, normally the commission, would have the burden. In addition, approval of the payment, either by the fund's board of directors or by its shareholders, is not totally dispositive, but is entitled to such weight as the court deems appropriate.
That was a compromise. The industry said that this should be given tremendous weight. The commission said it shouldn't be given any weight. Now it's given the weight that the court deems appropriate.
Now, in an action under 36B, they can recover damages, but only covering 1 year prior to the institution of the action, and the damages cannot exceed the amount that was paid to the advisor or the affiliate of the advisor. And it cannot include monies that were paid in connection with Section 17 transactions or monies that the affiliate of the advisor might have received, say, as sales loads if it were the principal underwriter for the fund. Finally, an action under 36B cannot be the basis for a proceeding under Section 9 or Section 203 of the Section 9 of the Investment Company Act or Section 203 of the Advisors Act to disqualify the person. Now, the Commission is currently involved in a proceeding, an injunctive action against the Fund Pack complex, which really typifies what a Section 36 action is all about. Now, in this complex, there are 3 funds. The lead fund is Fund Pack, which is a fund of funds, that is a fund which invests in other investment companies. The other 2 funds are income-oriented funds. One is a money market fund, and the other is a Ginnie Mae fund. Now, the management company's income is received, of course, from the advisory fees, but it's also received from the dealer concessions on the load funds purchased by Fund Pack. That is, when Fund Pack buys a load fund, the broker-dealer affiliate of the management company receives a rebate from the principal underwriter of that fund. And it's these dealer concessions that were really the primary source of the management company's income, and it was their grasping and doing everything they could to try and obtain more dealer concessions, which really led to many of the problems in this fund complex. One of the things that the management company decided to do was to promote the concept of switching. That is, the moving of a shareholder's holdings from fund pack to one of the other two funds in the complex. And the idea of this switching policy was to allow the shareholders to, at least in theory, enjoy the best of both worlds. They would be invested in fund pack, the growth fund of the complex, during rising markets, and when the market started to fall, the theory was that they would then switch into the income-oriented funds. And then, ultimately, when the market turned around, they would switch back into fund pack. Now, this unfortunately caused a number of problems for the fund. One set of problems was that fund pack was hit by a wave of redemptions. And the reason this happened was that, first of all, 60% of fund pack's assets were involved in the switching program. In addition, many of these shareholders were not acting on their own and not making individual decisions as to when to switch and when not to, but were in fact themselves relying on investment advisors, and in fact a limited number of investment advisors who told them when to switch. So what happened was the fund pack was hit by waves of redemption. Now, when they were hit by these waves of redemption, one thing fund pack could have done was redeem enough shares to meet the redemption requests. Now, the problem with doing that, and the reason they didn't do it, was that would have jeopardized the dealer concessions that they depended on so vitally, and that was sort of the lifeblood to the management company. So, instead of redeeming the shares, what they did was they borrowed money to pay the redemptions. This, of course, meant that the fund and its shareholders were incurring interest expenses. In addition, because during these periods when they'd been hit by these waves of redemptions but had not redeemed their own securities to meet them, the fund's gross assets were in excess of its net assets. So there was a leveraging. And the result of this leveraging, because it occurred primarily during declining markets, was that it magnified the losses that were incurred by the shareholders who remained. Now, part of our suit against this complex involved non-disclosure of both the risks of leveraging and the risks, and actually the burden that would be borne in the form of interest expenses. Also, another problem with fund pack was that it had a high turnover rate. In fact, in 1 year, the turnover rate got to be 950%. Now, this hurt the shareholders because they were constantly paying paying increasing sales loads. On the other hand, it helped the management company because they were getting more dealer concessions
from the sales load that the fund was paying.
There were two examples of how they were mismanaged. One, they purchased load funds instead of no load funds, even though the load funds were ranked lower on their internal ranking, and also they rejected methods to reduce the turnover. The directors ignored numerous red flags and really actively disregarded the interests of the fund shareholders. Their policy was whatever was best for the management company, that was what they were going to do. We've filed a suit and have obtained the appointment of a temporary special master to preside over the fund's activities, and I think this really typifies the kind of case that would warrant action under Section 36.
Thank you. This concludes the course, and as I said when we first started, after the completion of this course, if you weren't an expert on the 40 Act before, I'm sure you're not an expert now. But nevertheless, I do hope you got something out of it. The division stands ready to answer any questions that you may have. Thank you very much.